Welcome to the Insurance Agents and Brokers Podcast.
Hello and welcome to the audio version of Dawn's Discussion. Dawn's Discussion is a bi-monthly guidance column in IA&B's primary agent magazine and is written by Dawn Bankus, IA&B's Legal and Corporate Affairs Director. The question posed for the June 2026 column is it okay if my employees sign applications and related documents on behalf of our insureds? And the answer is, an insurance producer should never, ever sign an application, or any other insurance-related document for that matter, on behalf of a customer. There's no rewind button to go back in time and undo the fact you signed for your customer. The lower than recommended CGL liability or auto liability and property damage limits your customer chose and wanted that you signed for are not enforceable. The elections to waive UM/UIM and stacking that you signed, not enforceable. You can see where this is going. To court. Why all the worry? Even if a customer verbally authorized you to sign documents on their behalf, short of having them grant you power of attorney, it isn't sufficient. While a producer may know without a doubt the customer provided verbal authorization, after a loss has occurred and a claim has been filed, the customer/insured, if it's in their best interest, may disavow having granted the producer authorization to sign on their behalf. In such a case, the first thing a good attorney will do is ask if that's the customer's signature on the application. As soon as the customer says no, it becomes extremely difficult to hold them responsible for the content/elections in the application and other related documents and forms they didn't actually sign. Are there other possible repercussions? Yes, there are likely some serious ones, such as an E&O claim could be filed against you or the agency. Forging another person's signature on insurance documents is an express violation of the state's Producer Licensing Act. Therefore, you become subject to possible suspension, revocation, or non-renewal of your producer license, fines, etc. Not only in the state where you hold your resident license, but possibly in states where you hold non-resident licenses. You may have put your livelihood in serious jeopardy. You could subject the agency to termination by the insurance company for the affected insured. The agency's agreement with the carrier likely contains provisions whereby it can be terminated for fraudulent acts or for violation of certain state insurance laws or regulations. You could face criminal charges, even under circumstances where you know, for a fact, that the customer provided you with verbal authorization to sign. Even if you successfully defend the criminal charges, you could incur considerable costs. The bottom line, because you, as the producer, are not a party to your insured's contract of insurance, you should never, ever sign documents on a customer's behalf, even if they ask you to.
Insurance Agents and Brokers is the premier resource and champion for independent insurance agencies in Pennsylvania, Maryland, and Delaware. For more information, visit iabforme.com.
This is not a legal opinion and should not be relied upon as such. The intent is to provide a general background regarding the topic or topics discussed, not to provide legal advice. Producers and agencies should consult an attorney regarding specific situations and specific questions with respect to the topic or topics covered. Neither IA&B nor any of its employees shall be responsible for any errors or omissions regarding any statements made, nor any errors or omissions regarding any statutes, regulations, court rules, and/or any other government documents cited.